Okay, I pushed the wrong button and I got myself off. I'm here now.
So you just got 4 on here, Tom?
Looks like we now have 6.
Uh-huh. Okay, go ahead and start the recording.
I already did.
Okay. Okay, basically, I don't know whether you guys people realized it or even read it, okay? I had Tom post a document that I sent in, and I took into the court and had recorded for roughly about 12 traffic tickets. I reopened the case, ordered the reopening of the case, and basically turned around and ordered them to pay restitution for the harm done. It was a compulsory counterclaim against these brokers because basically those court cases were all done in fraud. Okay?
Yes.
And basically the fraud is that basically all of these courts, that are debtor courts, are not real courts. They're administrative, bank, and brokerage debt settlements. Okay? They're just a brokerage house, or like Payne Weber or A.G. Edwards settlement. All of our assets basically are held and under the control of the judicial brokers, okay? The court system in 1938 was changed from a court of law system and equity into this brokerage debt system that they have, and allowed the judges, these so-called judges, they're just brokers, to basically process our transactions, commodity transactions, because bonds and all their endeavors that they're doing are commodities. So they're commodity brokers. The state of Iowa basically is a holding company. Okay, and you can read the definition about a holding company. I put these definitions up there, along in that court case. They're also a brokerage, a holding company, but as a banking and brokerage firm. Our creditor, who is holding all of our assets, is a customer to them. Now, they have to try and find a buyer for our customer's transactions. When he wants to buy a bond, he got to find a seller of the bond. When he wants to sell a bond, they have to find a buyer of the bond. That's what they're doing when all of these traffic tickets, all these charges, governmental charges that they're doing, the IRS, they're trying to get us to buy our own items back to fund the bonds that are being written against those items. Our assets are being held there in this holding company. The holding company thinks that they're the owner of all this property, holding the titles of it. They can't sell them outright, our assets, for the customer, but they can claim ownership over them, and therefore then deprive us of the usage of those. When you know and understand this, then now you see that you have to have an attorney that has a bar card to process your accessing your brokerage, your creditor's brokerage account to make the settlement. If the bar attorney, public defender, or whatever, does not comply, you can go in and have his license, his bar license, revoked, just like a commodity broker at Payne Weber. You can file a charge against them in the process. The same thing with this court, with this branch. If they don't comply with your orders, then basically you can take them and do a B-10 in bankruptcy court against them, and that B-10 is a commercial lien. Now, as a broker or as a power, you have the attorney-in-fact power over your creditor's account, okay? You can basically go to the federal chief judge for the district and put an order in for $10,000. You can fax it in. Should be able to. Just like going to Payne Weber or whatever, you've got to have some written notice going into them. To get out of the system, you have to go to the head broker in the judicial system, which is the Supreme Court Justice for your circuit. To unplug from the circuit. And this is under a rigor juris, strictly of the law. Strict law. Strictum jus. Okay? You can look these definitions up. Your creditor is a conditional creditor. A creditor having a future right of action or having a right of action in expectancy. Okay?
Yeah, you said
now,
right of action.
when you get out of it, when you want out of the system, you're going to go to the Supreme Court Justice for your district. He's the chief broker for your circuit. And you can fax that into him, and it goes into the merits clerk. Why are there two clerks in the Supreme Court? You have one for the court of law, and then you have one for the merits. And merits is the word merit as a legal term is to be regarded as referring to the strict legal rights of the parties. And you're coming in under a condition meritorious, a condition which exists, and this was what one bankruptcy judge told a couple guys, but they didn't see it. It's a condition which exists where the event upon which an obligation becomes payable is in the power of the obligee. and is to be brought about by his doing or not doing a certain thing. Our creditor is the obligee. The broker, the brokerage house and broker are the obligors. But you have to come in and process it for your obligee, your creditor. That's what a condition meritorious means. You have 3 or 4, 4 or 5, basically different holding companies that you're dealing with. You have the state of holding company. You have the United States holding company. You have the Social Security foreign holding company. And you have the Church of Rome foreign holding company. And then if you've had military, you have a United States military holding company holding your military assets. You have to come in and you're going to have to sit in purgatory for 3 days because you're going to have to order the purging usury. You can look that one up. Purging usury. And that's removing the taint of usury as by abandoning the usurious agreement and the execution of a new obligation for the amount of actual debt, free from usury and bearing legal interest. That's when you will basically come out of their commercial treasury and go into the non-commercial treasury. A document that I put up there, basically I put it in for $130,000. Basically, it's a very simple 2-page document with roughly 2 pages of definitions. At the bare minimum, that is a $130,000 document. If anybody has any problem with me shutting this damn thing down and saying I'm not going to start supplying free damn stuff out here to people that basically would just want to sit back and run me down, turn around and use my documents. Other people use them. They don't know how to use them properly. And then for all my time and effort, I'm not getting shit out of it.
Right.
That's why I'm shutting everything down. This is the last call that I'll be doing. I've given you all the information you need to come out of the system. But if you think you've got to have trust, you think you've got to have all the other bullshit out there, go for it. I don't want to hear a goddamn thing about it because it's all bullshit. All this stuff that I got is really right out of the damn dictionaries if people would just look at it. The only 2 items that I had on there were against them for harms that they've caused. When I referred to 18 U.S.C. 242, it was against them for the deprivation of our rights per the Constitution. And then also 42 USC Section 1983, which provides additional liability against the perpetrator of the harm. Like I said, this is under a 3-day rule. 3-day rule is the time you have to spend in purgatory to basically for the purging usury of your assets. You need to read all those definitions there and then go over some of these other ones. Look up all the words that have anything to do with merits. Meritorious, merit. Condition, meritorious. Conditional, creditor, conditional contract, conditional obligation. Okay? The answer's here. So this is a $1 billion phone call.
Yep.
But you better know damn well what you're talking about and know these words when you go to them. But if you want to know how to deal with a broker, go down and get all the paperwork from Payne Weber or R.G. Edwards. I told you this before. I just didn't have quite all the pieces pulled together when I was talking about it before. We have to terminate all UCCs. We have to order the revocation of our signature on all B10s that we have done against our accounts, because the UCCs and the B10s are basically placing commercial liens against our creditor's account. Now, if there's a commercial lien against your checking account, guess what? You can't access that checking account. It's that simple. So you've got to put those orders in along with when you send your order up to the chief judge or to whoever. You can have all your bills paid, but you've got to go through a broker, a judicial broker, an attorney that has a bar card. So all these people that have been trying to tell us to stay away from the attorneys were dead wrong. All these attorneys work on commissions. They're brokers. But we need them to broker our accessing our creditor account. It's that damn simple. Okay, I'm done. You got any comments, questions? How many's on here, Tom?
We had 11 the last time I looked. Yes, 11.
Okay, this is you guys' last opportunity to ask any questions if you can't understand what the hell I just gave you.
Yeah, I understand what you said. I've been looking at the documents right now. I kind of wondered about that because you see these rappers and stuff. They hook up with an attorney, or they're in business and they're recording artists, and all of a sudden they got millions of dollars. And they couldn't have made that much money because the recording studios don't pay those guys that much.
Oh, yes, they do.
Oh, okay. It seems like they access some accounts or something.
Now, the recording studio, if they know what the hell they're doing, yeah, they're turning around and putting a lien against the rapper's creditor's account.
Right.
A B10. and then selling the B10 out, doing a B210A, and transferring that commercial lien to a broker to fund the damn payment that they just made to those wrappers for the expected profits that they're going to get.
Is that the technique you mentioned earlier of how attorneys play games with our accounts within the bankruptcy rules?
Sometimes, yes.
Okay.
Now, see, most of these guys, an attorney cannot access their own account. If you have a broker's license, you cannot trade your own account. Okay? I am a broker in fact. Okay? Because I took the broker's test, commodity broker's test, and I passed the test first time out. I didn't get the broker's license because I wanted to be able to trade my account. So I didn't get the license. But all these attorneys and all these brokers that got the license, they can't trade their own account. They have to go through somebody else. And then in a lot of cases, they still don't realize that they have an account sitting there with this much funds in it. If they did, they would basically revoke the bar license and start getting their access to their funds and just go be a man of law, an attorney of law. In fact, not attorney in law or at law, but an attorney in fact. If they want to continue that profession, if they think they really do know the law. Most of them still don't know the law. But that's the problem, okay? That's why you have female so-called people that claim to be judges. They're not judges. They're just administrative brokers. Okay, any questions? Okay.
Wow. Nobody has any questions?
Yeah, everybody knows all this shit. They rather they don't believe it. It's too damn simple.
Well, you told us to look up the words like merit and meritorious and all that, and condition and conditional and all that. So we'll look at all that, and we should learn all that first. I mean, I understand how important those words were that you mentioned.
Yeah, and then basically going from the benefit of sessions. That one right there tells you one hell of a lot. You have given all of your assets over to your creditor. Therefore, they cannot hold you in imprisonment. But they try to. They try and intimidate and force you to get your consent to turn around and be the liable party for the buying of the bonds that they're going to write against your creditor's account.
Yeah, I see the word benefit of cessation, yeah. Session, you mean. I've never seen that word before.
Well, I talked about that the last call.
Yeah. Who has assignment all his property to his creditor. Corporate person.
Infringement of patent. Letters of patent.
Yeah.
You have that, basically a letter of patent, letters of patent, an instrument evidencing the grant of a patent for an invention. Your body is an invention. It's a royal or governmental grant of property. You are a Terra. So you have a letters of patent, which that certificate of title is, that that is being held in the brokerage house, the holding company, and the holding company is trying to claim that they're the owner of that patent. Because you haven't come forward and claimed it and ordered the closure of that creditor's customer's account.
So a complete package on all of this is we still have to have our updated patent. We have to do our Homestead Act before we are really in the position to issue this compulsory
You
counterclaim.
should be aware of them, okay?
Okay.
You should have a will, okay? Also, a private will. You have to get some sort of recognition that you can turn around and put a claim in for your district court up to $10,000. If you want to buy a new vehicle, you turn around, take the invoice and everything else, and you take it to your broker for the district. Have him broker that account. That's what I did, basically, essentially, when I sent 7 IRS letters up there to the chief judge. I said, here, you take care of this. Well, he's the broker. He had to broker those if they had any valid charges. I wasn't going to play the buyer.
Hmm.
He wants to find a buyer for those damn things. Go and find a buyer, but I'm not going to be the buyer. I'm the true owner of my creditor and his account. And I'm going to come in and I'm either going to utilize my creditor's account the right way, just like a Payne Weber or H.E. Edwards or any other stocks and commodity trading company. I'm going to come in as the trader for that account. Why does he have to have a last name? Because an account has to have a permanent fixed name. You as the living don't have to have a last name. And then you've got a different birth date. You have a birthing date where he has a birth sack date. And his assets are being held in a sack. They're in this holding company. So the state has claimed your birth sack to hold your assets, the mirror image of you, but a permanent mirror image. That birth sack, basically the dead tissue, ain't going to grow anymore. It's permanent. It's reached its maturity.
Would the benefit of bargain rule apply to the fraud they do with the driver's license? Because you're expecting to have a license for the living man that's doing the driving, and they're just licensing the bankrupts so that they can, sell bonds.
Yes, if you know how to read that, yes.
Yeah. I mean, that's what I'm looking at there, right? You're relying. You're relying.
All of these words, basically, they are very key out here. Yeah. Duties, obligation, which imposed by the common law, statute, or contract when a right is invalid or if right is violated, a duty is valid. A right is invaded. Okay,
yeah.
A duty is violated.
Yeah, obligations, whether imposed by the common law, statute, or contract, where a right is I can't read that word.
And then basically they have a broker's blanket bond over your account.
A duty violated, right?
And this broker's blanket bond is called a fidelity bond, protecting a broker against loss through fraud and dishonesty of employees. Well, anybody that went in and basically looked up a certain number back in the fidelity bond system came up that they had an $11.2 million bond. Everybody has an $11.2 million bond over their broker, their creditor's brokerage account.
Wow. Did you call that a blanket?
Now this is all coming together. You are the holder in due course. As the patentee, you're the holder of that certificate of live birth. The holding company is a super corporation. Read the definition and you'll see that it fits right to the T of what the government is.
Right.
And then ownership. The very last thing says in there, provided the rights of others are not thereby infringed or some law violated. The right of disposal of a thing as one pleases, provided the rights of others are not thereby infringed or some law violated. They can't sell our stuff, but they claim ownership of it under false pretense and false representation of the facts to mislead you. Court of justice? Bullshit. It's a court of total injustice because they're using usury, unjust exchangement. You're the one that has to come in and force their hands. You have to know that you have a brokerage account and you have to treat those attorneys as brokers. And if they don't comply, then you can have their bar card, their license revoked.
Right.
Is that what the filing of the B-10 against them does, is revoke their bar card?
That would be placing a lien on their liability bond.
Okay.
You can also turn around and file charges into the administrative court administrative office. Because that's just a brokerage administrative, and you're filing a complaint against that broker for not complying with the rules of being a broker.
Okay. So that when the judge doesn't act, the chief judge doesn't act, the B-10, the administrative office.
No B-10s, okay?
Not on him?
You said B-10s?
Yes. I thought your document says that we do a B-10 against the people who won't broker properly.
Yes, after the fact. You're going after their liability bond. Their fidelity bond that they have also.
That's if
okay,
they don't
they
settle
also have a fidelity bond. We have a fidelity bond over our account also.
Right. We don't broker ourselves. We broker them when they won't settle.
And they won't settle. Then you can place a commercial lien against their fidelity bond.
Okay.
But you can also go in and have their license revoked.
Good.
Because they're not compliant as a judicial broker that they're supposed to be. And all bonds commodities. So they're really commodity brokers.
So we firmly have to get in our mind.
BAR, Brokerage Authorized Representative. That's all they are. They're a judicial brokerage authorized representative. All your assets were initially deposited by the court into the brokerage holding company. So you've got to go back to the judicial brokers to get your assets out of the brokerage account, not to any of these other places. And if you don't use a broker, you're not going to get it. They will take out their commissions out of the deal. You don't need to pay for any attorney out of your back pocket because you're going to be basically having a transaction come out of your brokerage account. He will get paid out of the commission of the sale or the transaction of that out of your account.
So in one way, they should be happy to settle with us.
Do we give them an allowance? Do we state that in the beginning, or do they have to make a claim in the beginning?
You're going to have to state that up front, that you know what the shit you're talking about.
Right.
I mean, you don't walk in a Payne Weber and start talking about, I don't know, being in the doctor's office.
Yeah, I know.
You're there for a certain thing. You've got to know what you're talking about in that office.
Right, so that's like a negotiable item. His fees are like you have to arrange that.
They probably have a set fee.
You don't worry about the negotiability of that, really.
Right.
You just go in and get it so that basically you can get some of your funds out of your account.
Right.
Okay, your creditor's account.
Yeah, go get $130,000 or something to start with.
No, $10,000 is the max you can get at your chief federal district.
Oh, okay.
Okay, that's per Title 28 U.S.C. 1346. I've said this numerous times. I've had that posted up there. To liquidate your accounts, you're coming in under Title 28 U.S.C. 1491. The mirror image of basically the HR document that took our assets away from us to begin with.
Right.
And that goes to the Supreme Court Justice. Doesn't say judge, that they're wearing two hats, as a justice or as a judge. A justice, they are a man of just exchangement, a just broker, the supreme just broker or judicial broker in the country. And they can basically issue the orders out to go and have the U.S. Marshals seize the assets from the foreign holding companies, like the Social Security holding company or the Church of Rome holding company.
Right.
That's what we were trying to find. Now, anybody else have any questions out there? This is your last chance, unless you're going to start paying for it. Told Tom, you want anything from now on, you send me a money order for $25 or $25 in cash and a stick file, and I will put some audios on it, and I will send it back to you. some documents that I've got written up, like the fax numbers, but you can find them yourself for the marriage clerk at the Supreme Court. I posted those up there before.
That's
you can get a hold of your fax number for your chief judge. I did.
And
why can you get those fax numbers? Because you're going to a broker. You've got to be able to put your order in. And faxing an order in is a lawful document. You can fax your signature in on that document supporting the order and follow up with a hard copy if they need one. You do not send an original certificate of live birth in with it, but you can send a copy in, proving that you have control of that creditor's customer account.
You had mentioned you'd prefer money, postal money order.
Yeah, postal money order.
And didn't you also want them to? Didn't you want them to include also a self-addressed stamped envelope for a return?
Well, they need to have the right address, but basically, if they're sending a stick file, I'll take care of the mailer, double packing, and send that back to them.
Good. Thank you.
Whether it's on a CD or whether it's on a stick file.
I interrupted someone.
Yes, I was just wondering if we do the bankruptcy and the patent filing on our own and then go to a broker, or do we...
Stop it. Cancel that. We were out of sync on that.
Okay.
Okay? Doing the B-10s, you're filing a commercial lien against your account. You're freezing your creditor's account. You need to order, if you have any B-10s against it, you need to order the revocation of your signature on those B-10s. Void all those B-10s because they were done by mistake. And then you have to go to a judicial broker on the other side of the aisle, the chief judge, or an attorney in your local town, and have them process it up the ladder.
Okay.
Or go to the Supreme Court justice, the supreme broker in the country, for the liquidation, outright liquidation of your accounts.
So we could go to the county attorney for him to get it to the chief judge, or should we go straight to the chief judge?
Go straight to the chief judge.
Okay.
He's just another broker.
All right. Something else that can go wrong.
Yeah, if you can get access to the chief broker for the district, why not go directly to him?
Right.
So
Patrick,
we don't want just a...
Go ahead, RC.
Go ahead, ask
we
a
don't
question.
want so do we want just a regular broker or a federal broker?
You've got to have a judicial broker,
Okay.
a bar attorney.
Okay.
That's what I was trying to tell you. You don't go to Payne, Weber, or anything like that. You've got to have a judicial broker because these assets are being held in the judicial side of this holding company. Okay, somebody else had a question. Ask your question.
Yeah, Kirk?
Yeah, this is Kurt. Patrick, you mentioned earlier that the UCC filings puts a lien against our creditor's account. I have done that in the past. How do I undo that?
That's what I just told you. You basically can turn around and send a notice into the bankruptcy court saying that you are revoking all signatures and B10s that you have submitted in the past.
Okay. I didn't realize the bankruptcy court would undo the UCC as well.
No, they won't. But basically you can make the statement that you're voiding all UCCs in the process that, and basically you're also, when you go to the Supreme Court Justice, you're going to write up that you have ordered the revocation of all B10s, all UCCs, and all other liens that are against your account have been done in fraud with fraudulent intents. Therefore, they are void.
Okay.
And should we
if
notify
any attorney or anybody like that has placed a lien, or the IRS or anything like that has placed a lien against your account, they were done in fraud.
Okay. Should
Awesome.
we notify?
Does that include the?
Should
Does
we
that
notify
include the EIN number?
Okay.
No.
Sorry.
You can notify them that you have EINs out there, but they will find that, and basically if they need to have you terminate those, they will tell you to terminate those.
Okay.
Okay.
Should we notify the secretaries of state about our termination of the UCC?
If you want to.
Okay. Just a safety measure then.
They're all operating in fraud. You notify the judicial side, you've notified them all. They're all in bed with one another.
Okay.
Oh, that makes good sense.
Yeah, it isn't a broker holding company, it's a firm. So basically, if one office in the firm knows something, basically, then all the offices in that firm are held liable for that knowledge.
Okay.
It's the principal notice to agent and notice to principal, notice to principal, notice to agent.
Yes, and you're notifying the chief broker.
Okay.
You can notify the Attorney General. He's the chief financial officer. That if he has any liens or anything like that, they were done in fraud.
Okay.
That's about it. I mean, you look over these items and you go over those other additional words that I threw at you there about merits, about purging, about conditional. Look those things up. Condition, okay, of the contract. All of our conditions, the conditional contract has reached its fulfillment. That brokerage account was only supposed to be there until we turned the age of 21. So its fulfillment has been completed. But they're still trying to hold it from us because we haven't come in and claimed it away from them.
So
why is it their obligation, the court's obligation, to make the payment? Because they're the broker over that creditor's account.
Right.
Now,
we
will
have to
that
keep
get
in
us will
One
that
at a
get us
time.
an income?
Huh? Speak up a little.
Will that, what you're suggesting now, will this get us an income right away? Because I'm afraid to stop my Social Security. until I have some kind of income.
You basically just keep going, okay? And like I said, it's only going to take 3 days to settle this damn thing when you go to the Supreme Court. So you can put an order into the broker to the district for $10,000. That's a hell of a lot more than you're going to get out of Social Security over the next 6 months, isn't it?
Right.
Okay.
Get them both going.
I mean, 6 months compared to 3 days, come on, you ought to be able to have, if you get $10,000, you ought to be able to last 3 days on $10,000.
Oh, yes.
Okay. This isn't rocket science here, people. People have gone out and bought stock in Walmart with a stockbroker. This is the same damn thing. You have an account. A stockbroker is the same thing as a commodity broker in most regards. And they hold your stock until you come in and demand the certificate to be sent to you. If you have state accounts, basically, like the driver's license, like a marriage certificate, you might have to go to the marriage clerk on your marriage to the state Supreme Court justice. But it's all right there. The system, I told you, from that document I put up the other day for $130,000. This would stop any mortgage. You can turn around and come back after them for harm, for the fraud that was perpetrated. And then also have the assets come out of your account in the process. But that bank basically is the real true debtor in the process. They were holding your funds away from you. You have to get those funds transferred over to your creditor or over directly to you. You have to start getting a little backbone in this damn process. You can't be wishy-washy about this. You have to understand. I told you, to cultivate your land, you have to plant the seeds of knowledge to gain the fruits of understanding.
Mm-hmm.
That's how you cultivate your land, your body. And if you don't get those seeds planted right, just like the sower in the Bible, that Jesus, the parable. Some seeds fell on the rocks, some fell on the nitwits, some fell over here on the dingbats, and basically it didn't bring any fruit forward. Because the people didn't want to put the time and the effort in to water and bring them to life. And I've dealt with a lot of rockheads out here over the last couple of weeks that their mindset is so rock solid about going after trust and all this other garbage that they think that they know what the hell they're talking about, and they don't. All these people who've gone into court trying to argue law, you're arguing the wrong damn thing. It's all about money. and you have to know how to handle your accounts. Okay, any other questions? Okay, that's it. Last call. Good night.
Thank you, Patrick.
Okay.
Okay.
Thank you.
Bye.
Thank you, Patrick.